as we get started here today, the one thing that I did want to mention to the audience and everything is in the overnight, I'm sure all of you have had time to read the 500-page report that the ITC put out overnight regarding the TRIPS waiver.
All 500 pages.
All 500 pages. Now, to give you an idea, is the executive summary is 38 pages long. So, but don't feel compelled in reading it, because apparently, as far as we can tell so far, there's like little or nothing there. They were not asked to give a recommendation as to whether or not the TRIPS waiver should be expanded, but they didn't. So what they did is they seem to have collected all of the statements people have made for it and all the statements people have made against it into one report, as if members of Congress and the administration couldn't just search the internet and find that all themselves. But now it is all together in one place. The U.S. Chamber of Commerce has come out with a statement on it saying that it validates the importance of IP. I think that a lot of people are probably going to think that the report validates their position. So why we're still talking about a COVID waiver right now, I don't know, but we are, and next steps we're uncertain, so we'll stay tuned. The other thing that happened overnight is the Pioneer Group, I think I have that right, the Pioneer Group came out with a white paper explaining much of what we've been talking about over the last several days about in quantifying or attempting to quantify the reduction in drug development that will occur as a result of the IRA. So stay tuned for that. We'll do more coverage on IPWatchdog on that. But this morning, what we have in store for us, and I do realize we're getting started about 5 minutes late. We're not so bad for day 3, and particularly given so many of us had a wonderful dinner with plentiful wine last night.
Yes, thank you, Wolf Greenfield.
Yeah, thank you, Wolf Greenfield. I did not get home until after midnight. I suspect those of you staying at a hotel a little closer probably got there slightly before midnight. So patent attorneys are fun. We have fun, and we drink a lot, I guess. So it was a wonderful night. So thank you for those who were able to join us. So this morning, what we're going to do is we have the ladies from Choate, the partner, Stephanie. I'll introduce you, Stephanie Schoenwald. She is a partner at Choate, Hall & Stewart in Boston. She moderated a panel for me a couple years ago, and when she did that, I immediately contacted her and said, what do I need to do to get you to do this more often? Because moderating is really a tough thing to do, and she did a fantastic job. And so I'm always happy to have you a part of our program. Stephanie is a co-chair for the program. She does dabbles in prosecution. I think she does a lot of PTAB work, and she dabbles in litigation with, I suspect, the dabbling is with an eye towards what problems are you going to have at the PTAB with what you're doing in litigation, and what problems are you going to have at the PTAB with respect to getting the patent that you're trying to get. So I'll just kick it over to you and let you introduce the other two panelists and introduce the topic.
Sure. Yeah, and you've queued it up nicely, because where we're headed today is really to talk about what happens when you have, different disputes going on in different forums, and you have to really manage all of that and keep things consistent and tight and not step in it as you go along the way. So before we get there, I can hand it over to you all to introduce yourselves, but maybe I'll hand it to Sophie Wong, who's a partner in the IP litigation group at Choate Hall & Stewart, and Brianna, who's a principal in the IP litigation group. And I work, again, closely with both of these women in large part because we're sitting at the intersection of prosecution, PTAB work, litigation, and disputes that go on ex-US, including German litigation, UK litigation, and oppositions. And so we do quite a bit of managing disputes that are going on in all these different forums at the same time.
And we also literally sit like 2 offices down from each other in a row, so we interact all the time. So thanks everybody for being here. Third day, and I was on a panel yesterday, so I won't reintroduce myself too much. I think our conversation this morning, as Steph said, is really talking about the synergies between prosecution and litigation, and thinking about globally what your strategy is, and that's why the topic is masterminding multiple forums. And one of the things I would say that I had takeaways from the last 2 days is there's a lot of doom and gloom, both on substance and on policy. And one of the places where I think there's a little bit of light is that it means that we get to be creative. We get to come up with solutions, we get to advocate, and we get to work together to find a path forward. And that's what we do as lawyers. It would be very boring if everything were actually, sunshine and daisies. So I think one of the things that we want to talk about is, how do you do that? How do you have a cohesive strategy? What are the things that you should be mindful of? What should you be worried about? And then how you actually, find a path forward.
And I think that's a perfect transition to one of Brianna's key points when we were talking is, engage your counsel early.
Yes.
So.
Good morning, everyone. Brianna McGillicuddy, as Steph said, happy to be here with you all. One of the takeaways for me from the last few days is, we've talked a lot about regulatory issues, prosecution issues. We're seeing, things go through the court system. And, you have to think early about what your big picture strategy is across all of those various segments, and make sure that your teams are working together to advance your strategy in each of those. If you're looking at things in isolation, you're likely to have one thing go off the rails, and you're really missing an opportunity to make sure that you're putting yourself in the best position to fight the fight at the end of the day.
Yeah, so, again, we've sort of heard about the policy. We've heard about some of the legal shifts we're seeing in the law. And today, frankly, overall, we're about to move into the practical application. So maybe giving a brief plug for Brianna and my panels later, we're going to move into ANDA litigation after this, and then PTAB, the PTAB panel to close out the day. And quite frankly, we probably started the practical applications yesterday with the JDG panel that was going on. So, one of the things we were discussing was just the increasing amount of, again, work that we see sort of at the crux where you and your competitor have claims that have similar scope. You're now in litigation. Everybody's looking to see if they can capture the other person to put leverage on. There's the actual litigation going on. Oftentimes there's oppositions going on. And Brianna, one of the things we had talked about was too many people, and you're mentioning it just now, right? Too many people wait until you're at the doorstep of litigation to start thinking about what to do. So what kind of actual practical things should people be thinking about as, when you get a commercial product, for example, that's coming up to market, and how do you plan for that?
I think one of the most important things that you can do is put the other side's hat on your head and figure out, what is the other side going to say? How are they going to challenge the positions that we're looking to take? And do that early. Do that, not the day before you're getting something in litigation. Do it years before you know the litigation is coming, if you're able to, because then you can set your prosecution strategy knowing what fights are going to come down the road. Then you can work with your regulatory team to make sure that, what's coming out from the FDA is matching what's in your patents, so that all of your strategy is moving forward together. And it's really challenging yourself, looking at your own case and say, what are the weaknesses here? How do I get ahead of it? And then getting everybody in the same room to talk about it and figure out, brainstorm the most creative solutions to put yourself in the best position.
Right, and one of the things we talked about is, I realize we're making it sound like you're going to put a bunch of lawyers in a room and you're going to raise the cost of everything very quickly. But in our experience, really what happens is, if you do that right from the get-go and you have the team, with the strategy aligned, you end up saving so much down the road, and in large part is because you don't get yourself into some of the pitfalls. So Sophie, what have you seen? What should people be thinking about on the pitfalls front?
Yeah, and I would say, just on the point of doing this early, there are so many different ways you can do it, and I think we talked about this, which is, there are always, sophisticated entities will always have sort of the really formal war games, in-depth analysis before a product is going to launch. They're thinking about that before exclusivity ends. What are we thinking? Those can be very pricey, and those can be sort of full-blown efforts. But some of the things that we're talking about is just opening the lines of communication between your counsel, between, folks here in the US and your EP council and across the world, just so that they know, so that they have somebody to reach out to when they're thinking about, I'm going to put in an expert declaration in Europe, and it's going to say these wonderful things about the invention and sort of what was known in the art and blah, blah, blah. And then, in litigation, we're sitting here reading something that was filed 2 years ago, and we can do nothing. There's nothing. Our statement is out there, right? So I think it's just important to have those lines of communication so that before somebody submits something big, where you're actually talking about either your invention, what was known in the art, what the claims mean, you have some set of eyes on it who, and these are not really that expensive, to have somebody take a look and just think about it from the U.S. perspective or from the EP perspective.
I want to pause there actually quickly to say that the number of times that as a patent prosecutor, that I've had the litigation team come in and look at claims, particularly on important products, is high, and the feedback has been invaluable. So I would certainly recommend that when you have products and that you're seeking to cover at the prosecution stage, don't forget about the litigators. They're not that the prosecution team doesn't have a great sense of the law and how to pursue claims that are going to get you the right scope, but the litigators are used to ripping them apart. And so they can give you that sense of, here's how I'm going to rip it apart. And it helps, maybe not with that particular claim set, but designing a strategy where you have multiple claim sets that might come at it, all with different strengths and weaknesses, so you can hedge your bets a little bit on the weaknesses, where you might end up.
And not to tack on to the doom and gloom theme, but, as litigators, as litigators, we're used to attacking, as Steph said, but we've also seen where it's gone wrong, right? We've seen where those attacks really win, the strengths of those attacks, and having seen where things go wrong, help you in the next case make sure to prevent it down the road.
Yeah, you don't want counsel to tell you everything's great. Your patents are solid. There's not going to be any problems, right? Because what you want is for people to think really critically and to be honest about where the potential issues are. So some things, for example, that have happened, and with being very anonymous about it, use of the same expert. We talked about this a little bit yesterday, right? So in certain fields, there are only so many experts in that particular field who have the right expertise to talk about the invention at issue. Using the same expert in Europe, where there are certain very strict rules as to what you can talk to your expert about, and so you may not be able to get as much information out of your expert there, and they say certain things. Then in the U.S., you start using that expert, and now they're exposed to all forms of U.S. expert discovery, and all things come out, right? And so you just want to be careful and be mindful and make sure that you've vetted things across, especially if you're using the same human who's going to be exposed to much more intensive scrutiny in certain proceedings.
And we've seen that where it's, yesterday I thought the Joint Defense Group did a great job of talking about how you may want to use a different expert when you're in district court litigation versus PTAB, for example, because there may be slight differences or they may have a different presentation style. That just amps up when you have to bring in other countries' law. Again, the discovery styles, the way that reports have to go in. And so it just becomes even more important to be thinking about that again, especially in a field where there's only a few experts.
Yeah. Another pitfall is the squeeze between the 103 and 112 arguments, which we see play all the time, right? And so you have, arguments that you've put forth publicly where you're trying to defend as a patent owner against challenges on obviousness, and you're saying, no, things were not obvious. It was very difficult. The state of the art wasn't there. You couldn't easily get here, right? All of the arguments you make. And then you're trying to then defend your enablement problem. Maybe there's an issue and you're trying to rely on the state of the art, and now you have to flip things over. And sometimes that happens in the same litigation, and it's, sort of that squeeze that as counsel you may be able to actually kind of figure out how to tread that. But if it happens in a completely different jurisdiction and you're not aware of it, suddenly you've got not only an expert, but you, the party, on record saying certain things about the state of the art, and you can bet that that's going to be used against you, right? So again, I think opening the lines of communication and making sure that the litigators aren't just focused only on their litigation. It's very easy to get sucked into a massive litigation and you're only focused on winning that particular case. But understanding that winning is global, right? We don't live in a society now that everything's limited. So you have to think about it and think about, what am I doing here? Is it going to have impact on what's happening outside? And then you have to know what's happening outside. You can't be sitting in a bubble.
I'm sorry, go ahead.
Oh, no, I was just going to say, to tack on to that, that's why it's so important to set your strategy early, because you might have these ex-U.S. proceedings happening 2 years before, as Steph said, you're in the U.S. So you need to know what your U.S. strategy is going to be well before you're actually, in front of the PTAB or the district court in the U.S., so that you're not making these statements that Sophie's saying that are going to come back to bite you in the end.
In the context we see this come up the most often is with oppositions, right? So you have a 9-month window in which to challenge a European patent. You take a look at it and you're like, I think we can make an inventive step argument here. You run the inventive step argument. You've made a bunch of statements about the art and the obviousness, predictability of getting to that particular scope. And then the fight comes to the U.S., and you probably should have paused before you went in whole hog on that opposition to say, do we have a 112 position in the U.S. on the corresponding claims? And have we just blown that, because that would have been our stronger position? And we see that quite a bit in the life sciences space, where people take a look at that first opposition, EP counsel doing their job right and doing a great job at finding those inventive step positions, but they really do then tied the hands of the U.S. Attorneys who later on have to fight the battle in the U.S., particularly on 112.
And part of the appeal to Brianna's point of starting early is there's often, especially when you have multiple law firms working together across different jurisdictions, right? Again, we all want to do the very best job we can for our client. We want to win in that circumstance, whatever that winning looks like. And so you sometimes see, if you engage too late, that firms and counsel are sort of at odds with each other, right? Because it's sort of, well, mine should be priority because I want to win here, or I should have, be able to make this argument. And that's not cohesive. And what's actually better is if you have early on a team mentality, that all of your counsel together with in-house, you're working for team company X, right? And so together you're thinking about, where do we make concessions? Where does it make sense to take the risk in the argument here in this jurisdiction, because it's really helping us here, and that's the priority for the business. And so thinking about it again early on, so you foster that sort of collaborative environment. That's the fun part, right? And for us lawyers, that's the fun part, is I get to learn a lot about what happens in Germany, and that would not be something I'm normally thinking of. But when you have that dynamic, it's much better overall, and you get a better result for the client.
And you get to be creative, right? It's
Yeah.
those moments when, the EP counsel would love to say one statement, the US counsel would love to say the other, and finding how to thread the needle. And when you find that spot and everybody gets excited and you're really starting to move things forward, that is a lot of fun.
Yeah, and I would say for in-house folks, and even, one of the things is and for outside counsel too, know your limits, be honest about what you don't have expertise in, and where you need to have somebody that you rely on, right? And so often what we say and what we do actually is we may serve as the central firm that kind of runs or masterminds the rest of the strategy across the world, but that does not mean that we are advising on what's happening in Europe or what's happening elsewhere. We then are responsible for sort of coordinating, and that's where outside counsel can be useful. It should not be actually a single person. We were talking about this, but it should be sort of a group effort. But having a coordination and somebody handling that is really important. So it's not it doesn't fall on the in-house person, who's already overburdened. But you have, someone who's actually looking at the big picture, and doing that again early is just so critical.
And sometimes it's just a matter of looking at a filing in one country, looking at a filing in another, and noticing the inconsistency and realizing you just have two groups of counsel who aren't communicating, and otherwise those things would get filed. So if you have someone who's coordinating it, they can pick up on those issues well in advance.
Yeah. The other thing just to jump in too, is it's not always defensive too, right? It's not always about, oh my gosh, don't say something that's going to ruin, what I'm going to do. Sometimes it's creative about like, here's what you could say in prosecution that would be really helpful for us down the road in litigation. Here's what you could, if you have like an office action and you put in something interesting here, that might be really helpful, 5 years down the line. And so you can be creative in using these resources affirmatively, offensively, thinking about how to make things better.
And we've been talking about this largely from sort of a patent owner's perspective, but if you are on the other side, looking at other jurisdictions can be a gold mine. I was in a PTAB proceeding several years ago where the other side was taking a very hard position about the interpretation of a claim term. We looked in their EP files. They had an opposition where they took the exact opposite. They took our position. And we were able to put that in front of the PTAB and say, isn't it interesting, right, that suddenly now that we've taken this position, they're flipping. And so nothing is more powerful than challenging a patent than using a patent owner's words from themselves to help your case.
And when you're in the throes of litigation, even if there's a statement that's been made ex-US or somewhere else, that may not necessarily be dispositive in the litigation, but it's certainly going to cause the judge, or if you're in a jury trial, to think twice about whether or not they can believe the patentee if they're really talking outside of both sides of their mouths.
And one thing I want to make sure people don't forget is that the Patent Office has other challenges and other mechanisms for being a little bit devious with prosecution. So there are third-party submissions, and there are ways to do them very well that edge on, get real close to making the argument, right? So, you cannot actually put in a end argument or end sort of conclusion in a third-party submission, but you can really set out the facts and do it in a way that tells your story so that the examiner picks it up and understands. And we've also been able to leverage protests in ways that are very helpful. And protests can, of course, be filed without necessarily naming the party that's underlining the filing. So protest can be another powerful way to stop the bleeding if you're in a litigation and the patents keep coming at you. It's a way to at least get the patent office to pause and think about it. So there are strategies, again, that kind of range from the litigation strategies, but even getting back to the patent office and saying, examiner, please pay attention to what's happening over here, so that you can minimize the damage.
Yeah, the other thing I would say, we've been talking obviously about IP and patent. Another thing, a lot of companies have sort of separate litigation arms, right? They have sort of patent IP groups, and then they've got commercial litigation and what's happening on the regulatory side, et cetera. Those folks should also talk to each other, right? It's really important to have lines of communication if you're representing counsel, particularly if you're thinking about in the context, for example, of joint collaborations, right? So a lot of times those types of agreements tend to fall within the commercial litigation side of the house, contracts, et cetera. And maybe you're prosecuting together, and so the patent prosecutors are also talking. What happens when you're jointly trying to enforce a patent that you both developed, jointly owned? You're trying to enforce it against a generic or a competitor. You're making all sorts of statements about the invention story, who contributed what, who was doing what, saying all these things, right? Because you're building up your case. And then you have a dispute in the collaboration, and now you need to fight over who owns the IP, who actually did certain things. If you're not talking, again, to each other, you may have put statements out there that you cannot walk back from, right? So it, again, makes sense for, especially in those types of contexts, have your people talking to each other and just understanding sort of, here's where we're going. Does anybody see any issues with this? Or know at least, and make sure your boards are aware, we are putting it all in here, and therefore if this comes back to bite us in a couple of years, or if there's an issue, everybody was on board and everybody understands the risk that was taken. But that's, again, sort of a piece where you can be stuck in the IP world and not necessarily thinking about the other aspects.
And Brianna mentioned earlier the regulatory team, so
Yeah.
I'd fold them in as well, because the number of times I've had a regulatory document going in, land on my desk, and the in-house IP person calls and says, you have 24 hours to get this into a patent application. is not minimal. So, just making sure everybody within the company is understanding the importance of the IP strategy and how it plays together overall.
Yeah.
So, Jean, I don't know if you have any questions. We haven't heard from you. It's a little quiet. It's the morning yet.
still
huh?
recovering.
Yeah, no, I thought
It's
you
that
guys
wine.
were yeah, it's the wine. I thought you guys were doing a great job, so I didn't want to interrupt you. But on that last point, what do you do when that happens? I mean, because obviously, if somebody drops something on you with 24 hours notice, and particularly in your field, where this is not, there'll be some cookie cutter stuff you can put in, but it's going to have to be a long, thick application. And I understand there's really nothing you can do. So I guess the question is, leading up to that, how do you manage the clients ahead of time so that you don't get them, or that when they do that, they understand the realities that they're going to be facing?
Yeah, and sometimes I think so you're right. There's very little we can do at that point in time, and we've now entered an age, as we've been discussing, where Amgen and Juno and Minnesota are all out there causing potential 112 problems for us. So getting it on file alone is not necessarily enough, because we may have an enablement problem. We may have a written description problem if we aren't able to build it out in a helpful way. So it really is about the in-house teams understanding and trying to do their best to communicate. And I think the best thing we can all do is just to help educate our clients on the potential impacts of that. Of course, there are going to be plenty of times where things just slip by and they can't control it. And I've rarely seen in-house counsel actually sit on something that they had in their hands for weeks, and suddenly it's got to get to you. It just doesn't happen. Mm-hmm. It's usually everything's moving fast, and we've got to move fast with them. So, in that moment, we have to do our best, but certainly getting it on file is important. And oftentimes it's reassessing the merits of that particular, that filing, and saying, okay, do we need to do another quick filing to, do any additional, text disclosure data that we need to get in there.
So, but now, just from a time-wise point of view, what do you do? I mean, what are the best practices, if any, other than running around like a chicken with your hair on fire?
It really is making sure that everybody on the team understands the importance, right? So we see it in the technical teams, we see it with the regulatory folks. It's making sure that the broader client is informed about the importance of having the time, getting the time. I mean, if we get a week, we're in much better shape than 24 hours.
Right.
If we get 2, I think we're on solid ground. So.
Yeah. So I mean, because and obviously the answer is different when it's a good client, and the answer is different when it's just a client, and the answer is even much more different when it's somebody who's coming to you for the first time and say, hey, I need help. I have a patent attorney friend who he got called by somebody who said, hey, my provisional is about to run out in 4 days. I have a problem. And his response was, yes, you do have a problem.
Yeah.
And I'm not going to help you. I mean, because we have no relationship right now. So it seems like those things are all about the relationship. And it shouldn't shock anybody that, your best clients get best treatment, I suppose. I mean, and I'm not asking you to comment on that. That's probably not fair. But I mean, but like you can't be a best client who has. So maybe the question is this: how do you get your clients to understand? Look, you can't do this to us every time, because there would be clients that if they get away with it once, then they're going to try and get away with it again, or they're at least maybe not try and get away with it isn't the right way to say it, but that they might think that they can.
I really don't have very many clients that I think, try to test those limits, especially in the life sciences space. Everyone understands, at least at the lawyer-attorney level, the importance of getting, the best possible product. And frankly, we're better counselors to our clients if we, are in constant communication. We understand their business goals. We understand their objectives for individual cases and technology. And my experience has been clients appreciate that and are often engaged, and so we just don't tend to get into those spots very often.
Well, that's good. I mean, that's good to hear because there's a lot of attorneys that do get into those spots, and I suppose if everybody understands the importance of the IP, then you don't. And I maybe, so I wonder, because I know that there are attorneys who get into that problem. So I wonder if it's just being extremely proactive with your clients and going and visiting them, or even now in the world post-pandemic, everybody is much more willing to use Zoom and get on a Zoom call and touching them, twice a year or once a quarter and say, hey, what are you working on? What do you have coming up? Do we need to slot any time, or, should we be aware of anything? Those types of interactions, I think, are worth their weight in gold to helping prevent this thing we're talking about right now. Right?
Yeah, and a lot of our clients, right, we would proactively check in, right? We have a provisional on file, to every 2 months. Is there any update? Any new data? What does your data timeline look like? Should we expect something in the next few months, so that we're staying on top of assessing that continuously? And I think that type of, again, proactive outreach is helpful for us, and it's helpful for them, right? Because a lot of times the in-house team is very busy, the technical teams are very busy, and if everybody just pauses and goes, oh yes, we got that data last week, we should send it through for you to take a peek at, it's super helpful for all of us.
Great.
Yeah.
Well, in the last couple minutes that we have here, Brianna, Sophie, do you have anything that you'd like to say or add?
I think just consistent with what we've been talking about this whole conference, which is that I think it's really important to work together. I think we just need to be able to coordinate and to think up, creative strategies.
So I do have a question specifically for you. You mentioned that, and I think it's absolutely great advice, that people should consult with litigators, particularly with important things. Do you actually have clients that do that?
Yes, all the time.
Okay. Well, that's good to hear too, because that's a level of commitment that is not altogether common throughout the industry.
I would say it is more common for especially our clients who are concerned about sort of loss of exclusivities, right? So we're talking about patent owners, brands who are concerned about that. They definitely engage litigators. But the one thing that I think I said earlier, maybe yesterday, was it doesn't have to be a full-blown sort of massive litigation exercise, which is what people think of. They think of a huge bill and all of these issues. And some clients want that and need that because they're going to have to go to their board and say, like, we've done this. We've kicked, the tires. We know what we're doing. It can be as easy as, and Steph and I right now have a client who we work with all the time. She's prosecuting the cases, and every now and then they have an issue where they're like, this claim set, we're really concerned. Let's bring Sophie in, and I come in and I spend a couple hours looking at it. We have a conversation, and then we figure out sort of what the right steps are. So it doesn't need to be as full blown, but it's good to have somebody constantly paying attention who understands what your goals are.
And we do that routinely on big clients, of course, who are getting ready to launch products, but on small startups as well, because frankly, with startups, the IP is their value. So they want to have IP that they can enforce, or at least gives them the right optics as they're going out for fundraising and discussion. So we tend to bring in the litigators quite often.
And if you encourage your prosecution team to do it, it takes the burden off of the busy in-house folks, right? If they're saying to Steph, please talk to your litigators, to make sure we're in the best position here, they don't have to be monitoring it at every step.
Excellent. Okay, well, thank you very much. So I can ask Sophie.